Hello everyone, it's Elena and I'm back with another video, and today we're going to talk about two capacity-based defenses, the defense of automatism and the defense of insanity. The two are related, which is why I decided to put them in one video, and this video is really meant to be a little refresher in your brain. So if you haven't read over that chapter of defenses in a while and you're about to revise it, then this video is for you, and it's hopefully going to give you a useful overview of the two defenses. We're going to start with the defense of automatism. So what do you need in order to use the defense of automatism? So according to the Attorney General's reference number 2 of 1992, the defense of automatism requires a total destruction of voluntary control on the defendant's part. Impaired, reduced or partial control is not enough. So it means you really have zero control over what you're doing, and then that defense can apply. Now in the Bratty case, it was said that there are two kinds of automatism: insane automatism and sane automatism. Now the difference between the two is what is the causing factor for the defendant's behavior. So is it an internal factor or an external factor? So an external factor would be, for example, if somebody takes a stone and hits you on the head with it, and because of that you lose control over your actions and then you commit a crime. So that is an external factor, and that counts as sane automatism. So you can raise the normal defense of automatism. But if instead you have an illness, like say for example you have an epileptic shock, that is an internal factor, and that counts as insane automatism, meaning you can't use the defense of automatism, but actually insane automatism means you have to use the defense of insanity. And if that defense is successful, the defendant will be found not guilty by reason of insanity under Section 2 of the Trial of Lunatics Act 1883. And that basically means that yes, the defendant is not guilty, but it is not a full acquittal because it's not guilty by reason of insanity. So that means the courts could give the defendant a full discharge, but the courts could also, for example, give a supervision order or a hospital order. So it's not like automatism where if the defense is successful, the defendant is acquitted, because found not guilty by reason of insanity doesn't equal a full acquittal. So we'll get back to that road of insane automatism in a moment, but for now let's look at sane automatism. So sane automatism means there is an external factor that is causing that loss of control. So as I said, if for example somebody hits you with a stone on the head and then that's the reason for your loss of control why you commit a crime, then that is sane automatism. It's also important to note that if you take something, for example a medication, and then as soon as it's in your body, so internally, it starts to then cause this malfunction, it still counts as an external factor. So that was for example the case in Quick, where the defendant took too much insulin because the doctor prescribed too much, and that was the reason for the defendant's loss of control. Now obviously that insulin only started causing that loss of control once it was inside the defendant's body, but it was still an external factor because the insulin was injected, so it was external at first, and that's why it counts as an external factor. Now in Quick, the defendant wasn't at fault because the defendant simply took the prescribed doses of insulin and the doctor had made the mistake of prescribing too much insulin. But what if you on purpose take too much insulin and you're just reckless to the consequences and you know that you may lose control? Then you are not covered by the defense of automatism. According to Bailey, if the state of automatism is self-induced, so you take something and then it causes you to lose control, the defense of automatism only applies if the defendant did not act recklessly in self-inducing that. So sometimes you may simply not know that if you take something, it may cause a loss of control. So you may, for example, not know that your body reacts in a certain way to a certain medication, and maybe you just have a very, very strong reaction to it, and you're absolutely not aware, and there's no way of knowing that, and you were really not reckless in not considering that risk, then you are still covered by the defense of sane automatism. But if you are, for example, somebody who takes a medication on a regular basis and you know that not taking it is a great risk of you then losing control, then you're acting recklessly, and then you would not be covered by the defense of sane automatism if you lost control and then committed a crime. The reason for that is pretty simple. The law doesn't want to reward reckless behavior. So obviously the law also doesn't want to punish you if you couldn't really know about the risk, but if you knew there was a great risk of that happening, why should the law reward you by giving you a defense with a full acquittal? That simply wouldn't be fair. So that's why if you acted recklessly in self-inducing your state of automatism, then you can't raise the defense of automatism. And yeah, that is pretty much the defense of automatism in a nutshell. And now we're going to get to the defense of insanity or insane automatism. So that is when the factor that is causing the behavior is internal. And the defense of insanity is a common law defense, and it is defined by the McNaughton rules. So McNaughton was simply a case, and after that case the House of Lords wrote down these rules which now define the defense of insanity. So under the McNaughton rules, the defendant must be found not guilty by reason of insanity if, because of a disease of the mind, he didn't know the nature and quality of his act, or, and then there's a second scenario by which you can also be found not guilty by reason of insanity. But we're first of all going to look at that first scenario. So the defendant is found not guilty by reason of insanity if, because of a disease of the mind, he didn't know the nature and quality of his act. So he really didn't understand what he was doing. That's basically what this means. So the nature and quality of the act are referring to the physical nature and quality of the act, not any legal or moral qualities or natures of that act. It really just refers to what you are doing physically, you know, and what that constitutes. And that's it. And the case for that is Codere. Now, as I said, there is a second scenario by which you can be found not guilty by reason of insanity, and that second scenario is that the defendant, even if he did know the nature and quality of his act, he must be found not guilty by reason of insanity if, because of a disease of the mind, he didn't know it was wrong. So he didn't understand what he was doing, he knew what that meant, what he was doing, but he didn't understand that it was a crime. So the term wrong doesn't mean, you know, morally wrong or anything like that. It means wrong in the legal sense. And once again, that is Codere. So that basically means the defendant is aware of what he's doing and he really knows what that act means, but he doesn't get that it's a crime. So the basic example here is if somebody believes themselves, for example, to be a messenger of some god, and that god had told him to kill everybody who, you know, stands in his way, and he believes it to be his divine right to do that. So he doesn't think it's a crime. He does understand what he's doing, which is killing people, but he thinks it's not wrong in the legal sense. And that's why that person could also successfully raise the defense of insanity. Now, the problem with the defense of insanity is that a lot of defendants actually don't want to have this defense because they don't want to be found not guilty by reason of insanity. And the reason for that is pretty much the stigma that is associated with it. When we think of the word insanity, we usually think, you know, okay, we're heading towards crazy town. But that is a really unfair stigma towards people who have to use this defense, because you can actually be found not guilty by reason of insanity with an illness like, for example, epilepsy. And I think in the normal use of the word insane, you would not label somebody who suffers from epilepsy as somebody who is insane. But the law does that. But the thing is, the word insane has a really bad stigma in normal everyday English. And that's why a lot of defendants really don't want to have this defense. And instead, they want to use the defense of automatism. But that is very often not open to them because the factor that, you know, causes the availability of the defense is internal. So they can't go through sane automatism, but instead they're on the route of insane automatism. A good example here is the Sullivan case, where the defendant had a seizure due to psychomotor epilepsy. And the defendant wanted to use the defense of automatism. And the court said no, because it is an internal factor, and the court did acknowledge in the judgment that it is somewhat problematic to label people with an illness like psychomotor epilepsy as insane, but they said, well, that is the law and we have to apply it, so that's why this defense is open to you, but the defense of automatism is not. That is really something that for defendants can be quite frustrating, simply because of the stigma that surrounds the word insane. And it is also really important to note here that it is not necessarily the defendant's decision whether this defense will be considered, because yes, the defendant is entitled to raise the defense of insanity, but so is the prosecution and so are judges, according to the Bratty case. And that means that even if you want to go down that automatism road, if the prosecutor thinks, well, there is a chance that this doesn't work under sane automatism, so let's also raise insanity, and boom, there it is, even though you didn't want this defense to happen. And the justification for this is policy reasons. So Lord Denning in the Bratty case argues that people who are found not guilty by reason of insanity are a potential danger to society, because those internal factors that, you know, strike that moment of insanity may strike again, and so these people may commit another crime when those internal factors, you know, are present once again. And so he argues that because these people may be a danger to society, both the prosecution and judges should be able to raise this defense in order to then, you know, contain this danger. But the thing is, if you're somebody who suffers from an illness like epilepsy and you hear this justification, it probably makes you want this defense even less. So While that justification is understandable in some cases of people who get this defense, it is also important to note that this just stigmatizes the defense even more. One last thing that's important to note about the defense of insanity is that the defense also applies to strict liability offenses. So strict liability offenses are offenses which have no mens rea requirement, so you just do the thing and that's it, that's the offense. No need for intent or anything like that. So for example, if you're driving while disqualified, it doesn't matter if you knew that you were disqualified or if you really wanted to drive while disqualified, it's an offense and that's it. And although the defense of insanity mainly refers to the mental element, so the mind of the defendant, it still applies to strict liability offenses, and the authority for that is the Hennessey case. And yeah, that is the defense of insanity in a nutshell. I hope you guys found this helpful, and if you guys have another legal topic that you would like to have a video on, please let me know in the comments below, or you can also send me a message through the contact section of my website, which is linked in the info box below. Thank you guys so much for watching this video. Have a nice day. Bye!